on the record in this matter. This time I am going to issue my decision on the request for a temporary restraining order. In this matter, the plaintiffs seek a temporary restraining order against Rule 80, which was an emergency rule passed by the defendant Ohio Liquor Control Commission that temporarily requires liquor permit holders to cease serving alcoholic beverages at 10 p.m., although patrons have until 11 p.m. to consume the beverage. That rule also alters in addition to altering those hours, it expands the ability for liquor permit holders to sell alcoholic beverages for off-site consumption. For the following reasons, the court is going to deny the request for a temporary restraining order in this matter. Looking at the factors that the court is to review, with respect to the first factor, the court is not persuaded that plaintiffs have a likelihood of success in this matter. Starting with plaintiffs' claims of substantive due process and equal protection violations. First, the court finds that the court is not persuaded that the plaintiffs are entitled to the intermediate scrutiny standard. As an initial matter, there's ample Ohio case law that liquor permits do not create property rights subject to due process. Further, the plaintiffs have not identified any unconstitutional classification or fundamental interest in this matter, and specifically no case is holding that liquor permits fall within a suspect class requiring heightened levels of scrutiny. Rather, the court is persuaded that the United States Supreme Court decision in Jacobson sets out the standard for judicial review of rights challenges to public health measures. Under Jacobson, a court's power is limited to asking whether the state action during a public health crisis is taken in an arbitrary, unreasonable manner or through arbitrary and oppressive regulations. The court notes that courts across the country have rejected similar challenges to COVID-19 limitations on business activities and gatherings, including denying temporary restraining orders on behalf of bridal shops, firearm retailers, gyms, business owners, and political candidates, campgrounds, adventure parks, challenges to curfews imposed on non-essential businesses, antique stores, and even health orders closing bars and limited service restaurants. As stated by the Sixth Circuit in Whitmer, the relevant standard merely requires rational speculation that offers conceivable support to the state's order, and this is essentially so in the case of a public health crisis like the one presented by COVID-19, where the state's latitude must be especially broad. The court is not persuaded that the plaintiffs have met this burden at this time. Court further finds that even if the court were to do a traditional non-pandemic standard review, the plaintiffs would need to establish disparate treatment between plaintiffs and a similarly situated comparator. And the court is not persuaded that the plaintiffs have identified a similarly situated comparator. The comparison made by the plaintiffs is between establishments serving non-alcoholic beverages and establishments serving alcoholic beverages. As identified in Commander Wolf's affidavit, the differences between alcoholic beverages and non-alcoholic beverages are obvious and are amplified late into the evening. For all those reasons, the court is not persuaded that the plaintiffs can meet their burden with respect to their equal protection and due process claims. The court's further not persuaded that plaintiffs can have a likelihood of success on the merits with respect to their separation of powers argument. The court finds that revised Code 4301.03 expressly empowers the Liquor Control Commission to adopt and promulgate, repeal, rescind, and amend in the manner required by that section rules, standards, requirements, and orders necessary to carry out this chapter. The rules of the Commission may include the following: Under letter I, it does state rules and orders with reference to the hours of the day during which and the persons to whom intoxicating liquor of any class may be sold. Also, in section B, the Liquor Control Commission is given the authority to issue rules and orders providing in detail for the conduct of any retail business authorized under liquor permits with a view to maintenance of public decency, sobriety, and good order in any place licensed under the permits. Accordingly, the court finds that the General Assembly expressly authorized the Commission to issue rules pertaining to the hours when alcoholic beverages may be sold and rules pertaining to the details for the conduct of business by liquor permit holders. The court also finds that pursuant to the revised code, the Commission has the additional authority to implement rules to maintain good order, something that is potentially jeopardized by the risk of COVID-19. With respect to the other factors that the court has to review for injunctive relief, with respect to the irreparable harm factor, the court does note that case law generally states that in the context of a request for injunctive relief, where the real harm that the plaintiff seeks to avoid is loss of money, the general rule is that harm is not irreparable. However, the court finds even if the court were to find irreparable harm here, the court has to balance that with the potential harm to others and the public interest. And a key consideration is the harm to the public if the injunctive relief were granted. Here, the public interest is served by the enforcement of laws intended to promote public health. As was stated by District Judge Marbley in the Hartman matter, and that was dealing with Director Atkins' order at that time. But basically, as Judge Marbley stated, if the order is enjoined, it is not merely livelihoods, but lives that would be put at risk. And the state has an interest in public health and the safety of its citizens. Also, as stated in Whitmer, enjoining the actions of state officials, especially in a situation where an infectious disease can and has spread rapidly, causes irreparable harm. Taking all of the factors into consideration, the court is again denying the request for a temporary restraining order in this matter. Counsel, I am open to how you would like to proceed as far as scheduling a preliminary injunction hearing in this matter. If you have any thoughts on that, we can discuss that now, or we can set a time where we can discuss that by telephone conference later.
Thank you, Your Honor. I will consult with my clients and determine how best to proceed. I think there's a likelihood we will still be asking for a preliminary injunction hearing, but I would like to go over those options with my clients and stakeholders. Thank you.
All right, thank you. That's fine. Then we will just wait to hear from counsel for the plaintiffs as far as how they prefer to proceed at this time. And then we can all get together and determine the scheduling of hearing if needed. With that, is there anything further than on behalf of either of the parties?
Nothing on behalf of the defendant, Your Honor.
Hearing nothing.
No, thank you, Your Honor.
All right, hearing nothing then. All right, thank you, counsel. Then we are adjourned at this time.